First of all, the wills, both wills, whether the Israeli will or the Israeli asset will and the Canadian will or the Ontario will, need to be very clear as to what the scope of that will is. What assets are you dealing with? So your Israeli will clearly set out, this will deals only with my real estate in Israel and my other assets that are located in Israel. And the Ontario will specifically say, this will deals with everything but my assets in Israel. As we heard already from Archie, you have to be very careful with those revocation clauses and ensure that the wills are signed in sequence and that the second will that you're signing doesn't revoke the first one. There's very often, or there may be situations where the debts or the taxes on the assets in the other jurisdiction should be paid out of those assets as opposed to out of the whole estate. And if that's the case, you have to be very clear about that in the wills that are being drafted, and to ensure that the right assets are being used to pay the debts. And that would be the case whether you're dealing with multi-jurisdictional wills or where you're dealing with wills that deal with corporate assets as a privately held shares as opposed to other assets. It's possible for the will that's going to be probated in Israel to be written in English or in other languages. Maybe preferable to be in Hebrew, but only, of course, if the testator actually understands Hebrew and can understand what they're signing. So that may not necessarily be the case. But yeah, and you may be, where it is in another language, you may require a certified translation of the will. And my last recommendation, though, on this, which I think is something that would have come out today as well, is you want to make sure that counsel in that other jurisdiction reviews what you've drafted to ensure that it will work in the other jurisdiction. I'm going to talk a little bit about tax issues and how they sort of the interplay of tax particularly here in Canada as well as in Israel. As I'm sure many of you are aware, on death, the capital gains that arise on the deemed disposition on death are going to be taxable in Canada, and it would include the worldwide assets. So if there are assets in Israel that have an accrued gain, you're going to be paying capital gains tax on those assets in Canada as well. There are though, whenever you're dealing with multi-jurisdictional assets, there's going to be a concern that there may be double taxation. Well, in Israel, there isn't an inheritance tax, so there's no sort of estate tax that you have to be concerned about when you're dealing with U.S. assets. But what you want to be careful with is if those assets are going to beneficiaries who are in Israel or in other jurisdictions, that when they go to sell them, they're not being taxed again on that same gain. There's up until fairly recently that was an issue in Israel. So if I've left my assets, my estate, to an Israeli beneficiary, they'll be paying capital gains tax in Canada. But what could happen was that beneficiary was receiving those assets at the original cost base, so my original cost base. There wasn't a step up in the cost base when they got into the hands of the Israeli beneficiary. So when that beneficiary went to sell those assets, there was a potential that, for Israeli purposes, they were going to be taxed not only on the gain from the date of my death, but from the gain that had already been tax paid on that in Israel. Thankfully, my understanding is there's been some recent relief in that area, and the Israeli tax authorities will now allow a step up in the cost base for non-Israeli assets that go to Israeli beneficiaries. It's a discretionary policy. It's something that in order to obtain this step up, you have to actually file with the Israeli tax authorities. So something obviously for Israeli counsel to deal with, but something that you want to be aware of when you're dealing with clients with those kinds of issues. There's also been some fairly recent new legislation in Israel on dealing with trusts, tax legislation. And interestingly, the way that trusts are viewed in Israel from a tax point of view is based on the residency of the settlor and of the beneficiaries, and not of the trustees. So whereas here we look very much, although there have been recent cases, obviously, that have changed the way we may look at the residence of a trust, but the residence of the trustees does come into play when you're dealing with trusts for tax purposes in Canada. Whereas, again, in Israel, they're looking to the residence of the settlor and the residence of the beneficiaries. They basically, and again, this is not Israeli tax advice that we're dealing with here, but just I wanted to give you a sense of what you want to perhaps look at when you're dealing with people with beneficiaries and assets in Israel. They basically broken down the trusts into three categories. The first one being where there's an Israeli resident settlor, so an Israeli resident settlor trust, a foreign resident beneficiary trust, and a foreign resident settlor trust. And these types of trusts, can be either inter vivos or testamentary trusts. And essentially the way that they are taxed will depend on which category that they fit into. I don't want to go into any detail on this. Obviously, I'm not an Israeli lawyer, an Israeli advisor, so this again is only sort of an outline of how things work. The best type of trust or category of trust that you could fall into would be the last one that I mentioned, the foreign resident settlor trust. So this would be where there's a settlor who's a non-resident of Israel, but one or more of the beneficiaries are Israeli residents. In those situations, there's not going to be Israeli tax liability on the gains or the income from property that's outside of Israel. And there's no reporting requirements for the trustees, although the beneficiaries would have to report any distribution. Now, it's critical, though, here that the beneficiaries cannot have any control, or so they can't be the trustees of this trust, or else they would be considered potentially to be the settlor of the trust. So these are the kinds of trusts clients who are either moving to Israel or have children who are moving to or living in Israel may want to consider setting up one of a trust for their kids or for their other beneficiaries. You do, however, need to keep in mind Canadian tax and trust issues. So, as I sort of started to mention, it may not necessarily be the residence of the trustees that determine where the trust is resident for Canadian purposes, but what you'd be looking at is where's the management and control of that trust. You want to consider as well the deemed disposition every 21 years and how that would affect the trust that you're setting up. And you also have to keep in mind that there would be no ability to roll property out to non-resident beneficiaries on a tax-deferred basis. With that, I guess do we open the floor for questions? No? No questions. Oh, good. Okay. Thank you very much. Oops. Taking somebody else's stuff here.
Frank sincerely regrets being unable to join us this morning, and there's nowhere else he'd rather be, but as you know, urgent matters prevented him from appearing. For 135 years, B'nai Brith has been serving the community with an enduring commitment to people helping people. The mission of the B'nai Brith Law Journal is to support our professional and student membership on important developments in Canadian law. We publish the semi-annual Law Journal and sponsor events such as these as part of our ongoing commitment to respond to issues of interest specific to the Jewish community and the professionals who service our population. By providing a forum for continued education, We hope we are securing our own future. On behalf of Frank Diamond and B'nai Brith Canada, I thank Charles Wagner for putting on the event this morning. And a special thanks to John Clegg, specialist in estate, trust, litigation, and guardian solutions with Scotia Private Group, who was unable to join us this morning. Scotiabank is an industry leader in managing and administering estates and trusts, and we're our sponsor here today. Charles, come up. I'd like to present you with a small gift as a token of B'nai Brith's appreciation.
Thank you. Thank you very much.
Zionists proclaim new state of Israel.
Mr. Gruda, would you please come up and...
I'm going to take Mr. Gruda's.
Mr. Gruda had to leave, and his presentation will be taken by Charles. And hand delivering it to Jerusalem. Archie, could you come up, please? Thank you very much for your information this morning. It's very much appreciated.
For a group photo op.
Ian Hull. Thank you very much. Jordan, who doesn't give pro bono at seminars. Thank you very much, Jordan. Dr. Shulman, thank you very much for your information this morning.
Sure. And I'm going to come on your side. Oh, let's do it.
Excellent.
Yeah.
Thank you.
Rachel, thank you very much. Ladies and gentlemen, we thank you for your interest in the B'nai Brith Lawyers Division and hope that you will leave here with a better understanding of the relevant issues relating to estates and trusts. Please join me in thanking our informative speakers and sponsor, Scotia Private Group. Have a wonderful day.